294th District Court. My name is Judge Chris Martin. I'm going to call this morning's docket. When I say your name, please say present or here and raise your hands so that I can acknowledge you for the docket. Ernest Bowie or Bowie. Ernest Bowie or Bowie. Don Dodd. Don Darrell Dodd. Vincent Freeney. Is this today's docket? Vincent Freeney. Matthew Gould. Here. John Legendray. How do I say that? Lejean. Eric Ketcherson. Kylena Ricard or Richard. Michael Spruce. Damon Gutierrez. Jason Mulligan. Braxton Henderson. Carissa White. Oh, looks like I have a note. That case was dismissed February 2nd. Also applies to CR 2274, dismissed February 2nd of this year. Matthew Kearns. Veronica Sturgeon. Thank you, sir. Brandon Harrison. Brandon Lee Harrison. Mr. Manning here? Mr. Schmidt? Okay. I just want to make sure he wasn't in the hallway with his clients. Scotty Petty. Scotty Dale Petty. Oh, I see. Okay. States that he has COVID. So we're going to, for the record, Mr. Sanders is in trial in Smith County. So we're going to reset all of Mr. Sanders' cases today until Thursday, February 10th. So we're going to do that for Mr. Petty as well and give him time to send in his COVID proof. Charlotte Robinson, verified in the Wood County Jail. We'll reset that to pre-trial to February 10th. Travis Skinner. James Bustamante. Joshua Hand. Okay, I'll recall it here shortly. Ralph Hanselka. Charles Howard. Leonard Purley. John Pickney. Avery Plunkett, verified in Dallas County Jail, CR 21268. We'll recall that. Leslie Gibson. Leslie Denise Gibson. Go, Mr. Stevens, on this.
Yes, because I'm not sure he's aware. It can't be, yes. Your Honor, I've been made aware that Ms. Gibson is the victim of a recent murder in Vincent County. So she's no longer with us, and I will be submitting a motion to dismiss her case today. I'm sorry, I have to tell you that.
Didn't know anything about it. I didn't know it was the same. I hadn't heard anything about it. Amy Harmon.
Here.
Heather Keels. Heather Lynn Keels. Wendy Jones. Wendy Marie Jones. Mr. Waters up here via Zoom this morning. I'll bring him in just in a moment. Jan Espino. Cody Eugene Gates.
Your Honor, my office, to contact Mr. Gates. I'm not sure. Might be in another facility somewhere. Have do that or else search him. There was possibility.
Okay, thanks, sir. Claude Souls. Edward Woodall. The rest of our cases are set for 10 and 11. Is Jose Herrera here? It's okay. And Tavares Dixon. Those are set for 10 and 11. Mr. Skinner, you'll come forward. We do a reset notice for Mr. Skinner to February 10th.
Already got it, sir.
Mr. Skinner, you heard me say earlier that Mr. Sanders is in trial in Tyler, in Smith County. So unfortunately, we're just gonna have to bring you back Thursday this week so that he can be here, okay? So have you signed this notice of appearance? I want you to check in with Mr. Waddell with pretrial release. If he doesn't need you, then you'll be free to go, okay? Yes. So we're also resetting Scotty Petty and Charlotte Robinson. We'll take those up again on February 10th for Mr. Sanders. What else? You want
Ms. Harmon is wanting to take a deal that we offered in October. It's for probation. The paperwork says October of last year. Because it's probation, would the court be all right with us just interlineating or do we do it either? Hopefully so.
So I've had these are my file for 2 months.
It's just probation. So it would just be the 1 day.
Yes, Judge, I do believe so.
Good.
Okay. As long as I'm fine with you just changing that. Get those out there.
It is Amy Harmon, HARMON, CR 21-120.
Thanks, Judge.
All right, for the record, court is dismissing cause number CR 2249, State of Texas versus Leslie Denise Gibson. Yes, Justin. So what I'm going to do is I'm going to call counsel. If you're ready, then go ahead and make a line right here, and then I'll call you up as I see y'all standing. All right, Mr. Adams, you ready? Who are you ready on first? Eric Ketcherson, CR 21-223. Mr. Ketcherson is set for docket call today, Mr. Adams.
That's right, Your Honor. This case is not going to be plowed out. We need a trial date.
All right, and Mr. Ketcherson understands that once we set it for trial, he's going to go to trial and court may not allow him to enter into a plea agreement after today.
He does that.
You understand that, Mr. Ketcherson? All right. All right, court will set Mr. Ketcherson for jury selection beginning February 28th. And Mr. Ketcherson, you'll appear on that day down in the basement of the courthouse. And I'll have a staff member down there. You won't go to trial on that day. And you'll need to continue to do that until your case is reached for trial, okay? All right, so continue to check in with your pretrial release officer. And when you're done today, I want you to report to the court collection officer at the end of the hall. I show that you owe some money on some old cases. So in order to avoid being arrested, possibly today, I need you to go down there and make a payment and try to get current, okay? So once you sign this notice with Mr. Adams, then report to the end of the hall and you're free to go.
Is that at 8:30 or 9?
8:30. Mr. Shar, if you'll make your way forward, please. Next case is CR 21-337, State versus Kylena Autumn Shar, set for pretrial.
Request for special jury instruction. This is another case that's gonna have to be, it's gonna have to be tried,
Do you want to set up for docket call or just go ahead and go right to the trial docket?
trial docket.
Court will set Mr. Richard then for trial on February 28th with the same instruction. Mr. Richard, you'll report down in the basement at 8:30. A member of my staff will be down there to assist you. You'll get a reset date. You'll continue to do that. Mr. Adams is not going to be required to be there at that time, okay, since you're not going to trial. You'll continue to do that until your case is set for trial, okay?
Typically don't really. In the hallway on the second floor.
So you're just meeting on. So,
At a table. Security desk.
will you catch her until? And if Mr. Catcher sits in the hallway, if you'll let him know as well. Michael Spruce. Sprouse. This is CR 21-247. Mr. Sprouse is set for docket call.
That's right. I have no issues to take up this morning. I feel like a broken record, but we need a jury trial date.
All right, court will set Mr. Sprouse then for jury selection February 28th at 8:30. And Mr. Sprouse, you'll enter the courthouse and there'll be a member of my staff out near the front door to assist you. Yes, sir. Is it Mulligan? Jason Lee Mulligan, CR 2404. Mr. Mulligan is set for pretrial today. Are there any contested pretrial matters, motions to quash, motions to suppress that need an evidentiary hearing in this case?
Not at this time, Your Honor, but I haven't completed discovery yet, so I'll anticipate having that done before the next court setting, so I'll be able to let the court know definitively at that time.
what, are you lacking discovery or just haven't reviewed it all?
You know, I haven't got any of it yet, so I'll be sending the request to have everything open on the portal today and possibly picking up DVDs if they're ready. If not, then I'll be back on the 23rd, which time I'll pick them up.
So has he not had access to discovery since arraignment? Wait for a minute, Mr. Woodline. So what I want to do is I want to make sure going forward that there's no delay. I usually set pretrial 30 to 45 days after arraignment. And I'm always curious as to if there are discovery issues, why those aren't taken care of before we come to court, because it unnecessarily delays the case.
But it appears we did not have it because the attorney for records discovery should be sent off with it right now.
And so counsel, if you'll just make sure when you're on the case, if you'll notify the DA's office upon arraignment, upon being retained, so that we don't have any delays.
Absolutely.
All right, so I'll reset Mr. Mulligan then for pretrial. You have your calendar with you?
I do, Your Honor.
Today is the 8th. How are you on March 8th or March 10th?
Both days I'm completely free, Your Honor, so whatever's more convenient for the court.
Okay, let's do March 8th. And I do have one other issue with Mr. Mulligan. So Mr. Mulligan, I believe, based on the records that I have here, when you were arrested on this charge, were you arrested out of county? In some other county?
Yes.
Where, okay, so what I'm gonna ask you to do, I'm gonna order you to do it, but I'm gonna ask you to do it, okay? I'm not gonna put you in custody and send you out to the sheriff's office to get your fingerprints. But what I am gonna order you to do is, I have here a document called TRN processing order. What this is gonna allow the sheriff's office here in Van Zandt County to do is to get your electronic fingerprints. So you're gonna have to go to the sheriff's office with this order, and they're gonna take you in. They're not gonna change you out, but they're gonna kind of go into the booking process so that they can get your fingerprints so they can report it to the state. So it's something that they have to do. Since you're arrested out of county, we don't have your fingerprints here in this county. So it's something the state requires law enforcement to do. And so I'm gonna order you to do that. They'll take it down there. They'll be as expedient as possible. Try not to delay you very long. They'll just take it in there. They'll fingerprint you and get you out of there, okay? All right, so I'm gonna sign this. I'm gonna give you a copy of this. Just take this along with your ID. A copy of these. Or do we just give them the original? Okay, so if you want to have a seat in the hallway, and then she'll make a copy of this, bring it to you, go down to the sheriff's office right after you leave here, get your fingerprints, and then sign the notice here with Mr. Dahman, and we'll see you back on March 8th. Okay,
What time is that, Your Honor?
that'll be at 9 o'clock.
And may I approach an unrelated matter?
Yes.
Judge?
himself, so that's his problem, right? Yes, Veronica Sturgeon, CR 21248.
You might recall, this is the client who has some PTSD issues related to her military service. Mr. Woodward was open enough to let me have her plead no contest to her, and we reworded the stipulation where it's, I just don't want to contest this charge. I just don't get it. So that's what
She knows this one.
yes, but she knows she's gonna be asked, you're freely and voluntary pleading no contest. You're not supposed to.
Morning, Ms. Sturgeon, how are you? Good. All right, this is cause number CR 21248. Ms. Sturgeon, if you'll raise your right hand, ma'am, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. All right, so your name is Veronica Anastasia Sturgeon, is that correct? And Ms. Sturgeon, are you a United States citizen? Do you read, write, and speak English? Have you ever been, you have to say yes or no out loud so my court reporter can take it down. Thank you. And have you ever been diagnosed with any type of mental condition?
Yes,
And is that PTSD?
yes,
Anything else?
I have ADHD and OCD.
Okay. And are you currently on any type of medication or undergoing treatment for those?
Yes,
Do you feel like that treatment or medication is enabling you to have rational thought and understanding regarding the proceedings here against you today?
yes.
Well, do you feel like you understand the
Oh,
proceedings?
yeah,
Okay.
So,
Yeah, so what I've got to make sure is that if you do have any of these mental disorders, that they're not in any way impeding your ability to understand what's going on.
I've
So,
had a lot of counsel, talk with counsel and my parents regularly.
okay. And in this case, you are represented by your attorney, Mr. Timothy Lacey, and today Mr. Casillas is standing in for Mr. Lacey. Are you pleased with the counsel that these gentlemen have given you?
Yes, sir.
Do you feel like you've had enough time to discuss the case with them and have all of your legal questions answered?
Yes, sir.
Is there anything about this paperwork that you've read, reviewed, and signed that you do not understand?
No, sir.
And you've read through everything, is that correct?
Yes, sir.
And Mr. Casillas, have you or Mr. Lacey explained the issues and requirements regarding the pretrial intervention contract to Ms. Sturgeon?
Yes, Your Honor, I have.
And do you believe that she understands all of the waiver of rights that she's giving up and that she understands how the admissibility of the offense reports and things of that nature could later be used against her if she violated any of the terms and conditions of the community supervision?
She does understand those matters, Your Honor.
And so, Ms. Sturgeon, I see here that you are charged by indictment with a second-degree felony offense of possession of a controlled substance in penalty group 2, greater than or equal to 4 grams, less than 400 grams. If you were to go to trial on a charge like that and be found guilty and convicted, and either a court or a jury were to sentence you, the sentencing range would have to be between a minimum of 2 years to a maximum of 20 years. So your punishment could be assessed anywhere between that range. Do you understand that?
Yes, sir.
And if you enter into this pretrial intervention contract, you would be stipulating to the admissibility of some of the evidence that the state would want to use against you. And if you violate any of the terms and conditions of this contract, the state of Texas could ask me to set you back on the docket and set you for a trial. And the trial would be before the court, not before a jury, because in this contract, you will have waived the right to a trial by jury. Do you understand that? Has anyone threatened, forced, or pressured you to make you feel like you had to give up any of your rights, including your right to a trial by jury?
No, sir.
You understand that by entering into this contract, if you successfully complete it, you can petition the court to have your criminal record expunged. But there's certain records that would not be able to be expunged. You would be waiving the right to have the DA's office records expunged. You would also be waiving the right to have the probation office records expunged. Do you understand that?
Yes, sir.
All right, the court's going to find that Ms. Sturgeon has been admonished as to her rights of waiver of jury trial and the limited waiver of expunction. The court will find that she has entered into the agreement intentionally, knowingly, and voluntarily, and with the advice and representation of counsel. So, Ms. Sturgeon, you would be placed on this program for a period of 2 years, and you've gone through the paperwork and you know what's required in order for you to successfully complete the program. Is that right? And it's, I believe it's your intention today to plead no contest to these charges. Is that correct?
Correct.
And you understand that a plea of no contest will have the same legal effect as a plea of guilty? Okay. All right. So Ms. Sturgeon, understanding the pretrial intervention contract, understanding the range of punishment, and all of the rights that you are waiving in order to enter into this program, I'll ask you at this time, how do you plead to possession of controlled substance, penalty group 2, greater than or equal to 4 grams, but less than 400 grams? Okay. And has anyone threatened, forced, or pressured you to make you feel like you had to plead no contest to this charge? Court will accept the defendant's plea of no contest. Mr. Casillas, is there any objection to any of the evidence attached to this pretrial intervention contract as states Exhibit 1?
No objection, Your Honor.
Court will accept the defendant's plea. Court will approve. The court will also admit the evidence in the pretrial intervention contract. The court will approve the placement of Veronica Sturgeon on pretrial intervention for a period of 2 years. All right, Ms. Sturgeon, I'm going to have you come forward and you're going to report to the pretrial release department, also known as the probation department, and they'll give you information about the next step, okay?
Honor, may I be excused?
Yes, thank you, Mr. Casillas. I appreciate you, sir.
Thank you.
We'll be back. Amy Harmon, CR 21-121. All right, Ms. Harmon, you will raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your name down. Your name is Amy Beatrice Harmon, is that correct?
Yes, sir.
Ms. Harmon, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
Yes.
What is that?
PTSD and depression, anxiety.
And are you on medication for any of those?
No, not at the moment. No.
Do you feel like you need to be on medication in order for you to understand what's going on?
No.
Okay, are you under a doctor's care for any of those?
No.
And in this case, you are represented by your attorney, Mr. Bill Stevens. Do you feel like you've had enough time to discuss your case with him, have all your legal questions answered?
Yes, sir.
Anything about this paperwork that you've read and signed with Mr. Stevens that you do not understand?
No, sir.
Mr. Stevens, do you believe Ms. Harmon to be competent today?
Yes, Your Honor.
And you explained to her her legal rights,
Yes, I did.
and you believe she understands them?
Yes, sir.
I see here that Ms. Harmon was charged by indictment with a state jail felony offense of driving while intoxicated with a child under 15 years of age, and that the proposed plea agreement is that she's going to plead guilty to that charge. State's recommending that she be convicted today, that her sentence be set at 18 months confinement in the state jail, and they're recommending that that sentence be suspended, and she be placed on community supervision or probation for 2 years, that she pay a $2,500 fine plus court costs and reimbursement fees. Is that your understanding of the agreement, Mr. Stevens?
Yes, sir, it is.
Ms. Harmon, is that what you understand?
Yes, sir.
That's what you're asking the court to approve today?
Yes, sir.
You understand that the range of punishment for a state jail felony is confinement in the state jail for a period of not less than 6 months or more than 2 years, and a fine not to exceed $10,000. Do you understand that range of punishment?
Yes, sir.
And what I've read here as your plea agreement would legally fit within that range of punishment. So understanding that, Ms. Harmon, how do you plead to driving while intoxicated with a child under 15 years of age?
Guilty.
Are you pleading guilty to that charge because you are guilty of committing that crime?
What am I supposed to say? No, I'm not.
You're supposed to say the truth. So I'm asking
No,
you, are
I'm
you
not.
pleading?
I'm pleading guilty because that's what I was told to do. But no, I'm not guilty.
Okay, you're not guilty. So Ms. Harmon, when you tell me that you're not guilty, then the court cannot accept any kind of agreement because it would be illegal for me to allow you to say that you're guilty on a piece of paper and then you tell me you're not guilty there.
Okay, well then, yes, I guess I'm guilty.
Well, no, it's not going to work like that either. So I'm going to recall your case. You're going to talk to Mr. Stevens about that. And Mr. Stevens is going to have to, he's got a tough job now. He's going to have to come back up here and convince me that if you want to change your plea to guilty, why I should do that. So I need you to listen to him and I'll recall that case in just a moment.
This one is Gibbs. Thank you.
Mr. Estrada, are you ready?
Yes, there's an announcement on Bryce.
Braxton Henderson, CR 21289. Mr. Henderson set for pre-trial today. Are there any contested pre-trial motions?
Judge, I wanted to make an announcement to the court. There's no pretrial at this time. On January 25th, some additional discovery was provided to our office, including an autopsy report. I will need to employ a forensic pathologist to review that autopsy report with me. In addition to, I may need to make a trip over to the SWIFT, the Southwest Institute of Forensic Pathology, which is in Dallas, to see if there's any additional documents that need to be included in the autopsy report. The state has no opposition for another pre-trial to allow me time to contract with a forensic pathologist, review the additional discovery.
How much time do you think it would take for you to get that done?
Judge, I'm thinking 2 months, 60 days.
State, any objection?
No objection. We understand Mr. Estrada's position.
Right now, Mr. Estrada, in April, I've got 3 dates. I got April 12th or 14th.
If I can look at my calendar. Judge.
Absolutely. Yes, sir. Please do.
April 12th would work, Judge.
We'll set Mr. Henderson then for pretrial at 9 a.m. on April 12th. Mr. Henderson, once you sign the notice of appearance and get the yellow copy, you're free to go. You here for Mr. Ashmore today?
Yes, Your Honor.
You ready on those?
I believe so, yes.
Oh, it looks like he just has one this morning, huh? Damon Gutierrez, CR 2169. All right, Mr. Gutierrez is set for pretrial today. Are there any contested pretrial motions?
No, Your Honor.
All right, there being no contested pretrial, we'll set Mr. Gutierrez then for docket call. And this will be the time that I want the state and defense to work together to try to determine if we go to trial or we're gonna try to reach a plea agreement, okay? So I'm gonna set this out 30 days or so. Do you know Mr. Ashmore's schedule?
I can, 30-day, I should be open, after this month. March is pretty open for us.
Okay, so I'll be looking at March 8th or March 10th.
That sounds right.
Okay, all right, so we'll set Mr. Gutierrez in for docket call on March 8th. And that will be at 9 a.m. And Mr. Gutierrez, you're gonna have what's called conditions of pretrial release to sign, okay? So once you sign this yellow copy, I want you to report over here to the pretrial release department. There's gonna be conditions on your bond. You're gonna have to report. You're gonna be drug tested. You can't commit new offenses. You violate any of these conditions, and I can withdraw your bond and put you back in jail, okay? So it's gonna be your conditions of pretrial release. Hang on just one second. Mr. Woodward, counsel urge. All right, Mr. Gutierrez, the court has set you for a docket call on March 8th. You're going to sign this notice of setting, Mr. Craddock, and then you're going to have conditions of pretrial release, like I mentioned to you. You're going to need to sign those. The only other issue, Mr. Gutierrez, is that I believe that you missed court in December. Is that correct? And you submitted some medical documentation to the court. I believe that to be fraudulent. I believe that to be a forgery. I don't believe in,
I was sick one day.
I understand, but I believe what you submitted to the court is, I think you forged a doctor's note and a doctor's signature. Okay, we've already looked into that. And the doctors told us he didn't do that. It's not a signature. So at this time, I'm going to find your bond to be, your bail to be insufficient. I'm going to place you back in custody, and your attorneys are going to talk to you about it. We can set a hearing. Understand? Okay, so don't say anything else. Wait, talk with your attorneys, but we're going to bring you back for a hearing on March 8th on your case, and we may be able to bring you back sooner to have a hearing on whether or not you should get back out of jail. Okay, so go with the bailiff this time. Yeah, you can go ahead and let him sign that. Mr. Stevens?
Yes.
Ms. Harmon, let's try it again. All right, Ms. Harmon, I previously swore you in under oath. You're still under oath for all purposes of your testimony. Do you understand that?
Yes, sir.
Go ahead, Mr. Stevens.
Thank you. Please state your name for the record.
Amy Harmon.
Ms. Harmon, you and I have discussed your case for many months, have we not?
Yes, sir.
We've gone over the evidence and discussed going to trial, different possible evidence.
Yes, sir.
Okay. And at one time, you actually decided that you wanted to go to trial.
Yes, sir.
And then later, we talked and you decided that you felt like you were guilty. You're not felt like it. You were guilty.
Yes.
And you wanted to go into something probation, is that correct?
Yes, sir.
Okay. Are you telling this court today that in fact you are guilty of this offense?
Yes, sir.
While ago, you made a comment that you were not guilty.
Yes, sir.
All that. Okay. In fact, is your plea guilty?
Yes, I'm guilty.
Do you say you're guilty because you are guilty? Is there no?
Yes, that's correct.
And you understand by doing that, if the judge accepts your plea, then you will lose your right to trial. You understand that?
Yes, sir.
You'll lose your right to confront witnesses and call your own witnesses. You understand that, correct?
Yes, sir.
Okay. Again, are you telling the court that you are guilty of this offense?
Yes, sir.
Are you satisfied with my representation with you pertaining to this office?
Yes, sir.
Are you asking the judge to accept your plea of guilty?
Yes, sir.
Ask witness, Your Honor.
State.
Judge, I have no questions.
So Ms. Harmon, you understand that you have the absolute right to a jury trial in this case?
Yes, sir, I do.
If you believe that you're not guilty, you have the right to require the state to prove your guilt beyond all reasonable doubt, all right? And that requires them to bring their evidence before a jury of your peers and prove each and every element in order for them to get a verdict of guilty and find you guilty and convict you and sentence you or put you on probation or any of those things. Do you understand that you have that right?
Yes, sir.
And no one can take that right away from you.
Yes, sir.
But you can waive that right to a jury trial and you can plead guilty only if you are truly guilty of committing the crime.
Yes, sir.
So as you stand here today, and I've heard what Mr. Stevens has asked you, and I've heard what your answers are, but I still want to know, do you feel like you've been forced or told that you had to plead guilty today?
No, sir.
And in a minute, I'm going to ask you again, how do you plead? And you're going to tell me that you're pleading guilty.
Yes, sir.
You're going to tell me that you're doing that because that's what you want to do and that you understand that you are guilty of committing the crime.
Yes, sir.
All right, Ms. Harmon. So as to the charge of driving while intoxicated with a child under 15 years of age, how do you plead? Guilty, not guilty, no contest?
Guilty.
Are you pleading guilty because you are guilty of committing that exact crime?
Yes, sir.
Has anyone threatened, forced, pressured you, or told you that you had to plead guilty?
No, sir.
All right, court will accept the defendant's plea of guilt. Mr. Stevens, any objection to states one?
No, Your Honor.
All right, states one is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we rest in post this time.
Thank you, Mr. Woodwhite. From the defense?
Rest in peace.
All right, the court's reviewed the evidence. I find that there is sufficient evidence to convict the defendant of this crime. Court will follow the plea agreement reached between the state and the defendant. Court hereby finds Ms. Amy Beatrice Harmon guilty of driving while intoxicated with a child under 15 years of age. The court assesses her punishment at 18 months confinement in the Texas Department of Criminal Justice State Jail Division. Court will suspend that sentence, place Ms. Harmon on 2 years community supervision, order her to pay a fine of $2,500, $290 court cost, and $535 reimbursement fees. So Ms. Harmon, explain to me what happens to you if you violate any of the terms and conditions of your community supervision.
I go to jail.
No, don't go to jail.
I mean, I go to prison,
Go to prison. And how long do you go to prison for?
2 years,
18 months,
almost 2 years, yeah.
Hmm?
Almost 2 years, yeah.
almost 2 years. You know, I think you're very lucky today. I know you don't feel lucky today. I'm sure it probably feels like the opposite of luck. Coming to court, getting convicted, having to go on probation for a few years, having to pay a lot of money, having to see a probation officer, having to pee in a cup, having to stay clean. I know that probably doesn't sound good. But is your daughter still alive?
Yes, she is.
You're lucky.
I know.
Because you could have killed her that night. 4-year-old little girl who had nothing to do but trust that her mama was looking out for her best interests and was going to take care of her, and got in the car and just depends on you for everything. I don't know if you have her right now, but I know that she's not dead. And that's why you're lucky.
I do have it right now.
Well, why don't you cherish that?
I do.
All right. All right, Ms. Harmon, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. Come forward to be fingerprinted, Deputy the Police Sheriff, and then you'll report to the probation department over here.
Keys.
Running late. I've got an office full of people waiting to get trial prep for the 14th of February. If she shows up, would you send her to the jail this afternoon? Is that possible?
I'll put her in jail, and then I'll bring her in.
That'll work.
Okay.
Would you do that, Judge?
I will.
Thank
For you,
Judge.
I'll tell her.
Appreciate it very
Attorney said
much.
she's in jail.
I'll be there this afternoon.
Thank you, Mr. Stevens. Appreciate you, sir. Mr. Schmidt, you ready? Yes, sir.
Your Honor, I think we've got the translator too.
Mr. Schmidt. I'm sorry. I'm sorry. I'm not. I forgot about that. My apologies. Mr. Herrera is Mr. Manning's though, is that right? Okay, yeah, I'm sorry. So this is you. Is he here, Mr. Herrera? Jose Guadalupe Rivera Herrera. Reach in the hallway for Jose Herrera.
You can hear me.
I have a note that says he was at no report to retrial. Is Mr. Dixon here? Mr. Adams, do you know if Mr. Dixon's here yet? He's not, okay. I was just, is he? Okay. Do you have any knowledge about Mr. Herrera's whereabouts?
Mr. Waddell believed that he was here, but
Mr. Waddell did.
He did, that's why we're looking for.
So we can- Mr. Waddell?
Yes, sir. He's making his way to the building. Yes, walk through the invitation.
Okay. Okay, Aaron was looking.
In the
she went
building,
there
so we're just
before you
waiting
saw
on-
it, told her we found you. We found Mr. Waddell.
Did you? Okay.
Yeah, as soon as you went there, he put it. That's right. Mr. Morales, does everything look to be set up okay on your end? Excellent. Okay. So did you hear what my staff member said that he's on his way up. He has limited mobility. Y'all talking about it. I'm sure.
There is no confirmation citing Mr. Pereira at this point.
What if Mr. Waddell seen an apparition?
Mr. Waddell was on the phone with Mr. Pereira's son. Son told Waddell. So we don't know if the man's somewhere else is lost.
So what did you say?
If you want me to go look for a handicapped Hispanic
Yeah.
older male, then I can do that. Or we can- I mean, without an interpreter, and I do know, Judge, that Mr. Manning's announcement that he requested me to make is that he was going to ask for additional pretrial on Mr. Pereira. But it's up to the court.
You have your own cases there. You do.
Yes.
Let's do this. Make sure I'm on mute here. Mr. Morales, when is your next hearing? How much time have you allotted for us? Yeah, if you'll just plan that for me, I don't want to keep you here. I'll go ahead and let you go. And that way you get ready for your next hearing. And then I'll have Ms. Abraham contact you if we're not going to do the 11:30. But if you'll go ahead and pencil me in for the 11:30, if we find Mr. Herrera, then we'll try to do that at 11:30. Thank you, Mr. Sorry about that. All right, let's go ahead and call your cases, Mr. Schmidt, because that's all Mr. Manning had, right? Was
I believe he had the two, but I'm not sure that the other person showed up. I'll double check those when we're done here. Let's see what we got.
you want to go on Mr. Pickney first?
Yes, please.
John James Pickney. Are you Mr. Pickney?
Yes, sir.
Mr. Pickney, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, Mr. Pickney, you may put your hand down. Mr. Pickney, are you a United States citizen?
Yes.
Do you read, write, and speak English?
Yes.
Have you ever been diagnosed with any type of mental condition?
No.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with his representation of you?
Yes.
You feel like you got enough time to discuss the case with him and have all of your legal questions answered? Is there anything about the paperwork that you've read and signed and reviewed, Mr. Schmidt, that you do not understand?
No.
Mr. Schmidt, do you believe Mr. Pickney to be competent today?
Yes, sir.
You've explained to him his legal rights and both the advantages and disadvantages of the deferred adjudication plea? And do you believe he understands all of those?
Yes.
Mr. Pickney, I see that you've been charged by indictment with a state jail felony offense of possession of a controlled substance of penalty group 1, less than 1 gram. A state jail felony such as this in the state of Texas, if convicted and sentenced, carries a range of punishment of not less than 6 months or more than 2 years confinement in a state jail prison. I see that the plea agreement that you've reached with the state is that you're going to plead guilty to that charge. The state's recommending that the court defer a finding of guilt in your case today, meaning that the court not find you guilty today, but rather place you on community supervision for 2 years and give you an opportunity to successfully complete that probationary period. In addition to that, you would have a $1,500 fine, $290 court cost, $535 reimbursement fees, and $180 restitution. Is that your understanding of the plea agreement?
Yeah.
All right, Mr. Pickney, understanding the range of punishment and the plea agreement, how do you plead to possession of a controlled substance in penalty group 1, less than 1 gram?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
I'm guilty.
Court hereby accepts the defendant's plea of guilt. Mr. Schmidt, any objection to State's Exhibit 1? State's Exhibit 1 is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we've rested.
Anything further from the defense, Mr. Schmidt? All right, Mr. Pickney, the court has reviewed the evidence in your case. I do find enough evidence to convict you of this offense. However, the court will follow the plea agreement that you reached with the state. The court hereby defers a finding of guilt, places you on community supervision for 2 years, orders you to pay the previously mentioned fine, court costs, reimbursement fees, and restitution. Mr. Pickney, you hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm going to have you step forward here to be fingerprinted. After that time, I want you to go over here to Ms. Burns, and she'll give you additional information about probation. Next,
I'm ready on
all of them.
Yes, sir.
James Bustamante, CR 21-9, CR 21-281. Mr. Bustamante set for docket call.
That's correct, Judge. We're gonna ask for an additional docket call. Mr. Bustamante is making progress with the VA, with their mental health services. We ask that he be given more time to work on that.
They,
Stands for rejection of Mr. Smith. It's the progress. It is. Making some progress and with
how long?
As long as the court goes, it's the VA, and the issue that we've had is a scheduling issue with the holidays. It should pick up, but they are slow to deal with.
Do we think we're getting close to a point where we can make a decision on resolution?
I think so.
About April 12th. That week I got April 12th or 14th.
Should be submitting a vacation letter shortly. It's in April. It's just-
What about April?
Actually, April's fine, Judge. I'm actually going in May, so,
Sure.
yes, sir.
April 12th?
Yes.
All right, we'll set him for a docket call April 12th. You got some documentation on hand. Joshua Hand, CR 21-168.
This is COVID positive. According to,
Does this say he was just, does this say he was positive or does it say he just went in to get checked?
it says positive. See,
Is it COVID? Diagnosis. COVID. COPD. That's has completed. SARS.
says organized disease 2019 discharge instructions. It's medicated for. I'm reading these diagnosed with COVID. because the diagnosis is covered.
All right, court will. Gotta get some, yeah, sure. Court will set Mr. Hand for additional docket call. April 12th. Sorry. Be available March 8th. Before I look on that. Court sets Mr. Hand for additional docket call March 8th. Ralph and Selka, CR 21-169, CR 21-170. Mr. Selka is set for docket call today.
That's correct, Judge, and same now as I'm asking for additional docket call, Mr. Hanselka. He had an appointment to meet with me to go over some of the discovery. He's a truck driver, so he's all over the place. We had the freeze as well as some sort of work injury, so we'd ask that we be given additional docket call. Hopefully resolve the matter by the time we come back.
All right, court will set Mr. Hanselka then for March 8th. 9 a.m. Charles Howard, CR 21-76 and 386. Mr. Howard set for arraignment in 386, possession of controlled substance, group 1, second-degree felony.
Judge, we arraigned Mr. Howard the last time we were in court. It should be a pretrial today. For the purposes of the record, we did wait for him to read and enter a plea of not guilty. As far as if the court wants to set that for pretrial, we'll take the time. And then carry the other case on docket call with it.
You're saying that today should have been a pretrial.
I believe it should have been.
You just go ahead and set it for docket call along with the other.
Fine with that, yes.
All right, court will set Mr. Howard for docket call in each case on March 8th at 9 a.m. Mr. Howard, I show that you're still behind on your payments to your pretrial release officer. Ask that you go and make a payment today. Leonard Curley, CR 21-234. Curley set for docket call.
Yes, Judge, I'm gonna ask for additional docket call, Mr. Purley. I think we can resolve Mr. Purley without a jury trial, but I need a little more time to strong arm the defense.
All right, court will set Mr. Purley for additional docket call on March 8th. And Mr. Purley, I show that you're delinquent on your attorney fees and your bond supervision, up at $180.
I'll get a payment made today, sir.
CR 21-268 and CR 21-269, State versus Avery Plunkett. I have Mr. Plunkett confirmed in custody in Dallas County. Do you have any additional information?
I do, Judge. It's my understanding from Mr. Plunkett's family member that they resolved that case. I believe, it's my understanding that he received a probation deal. So I don't know if that's already taken place, but it's my understanding it did.
Is that the only charge that you're aware of that was holding him in Dallas County? That he could be,
That's the only charge that I'm aware of. But, yeah, I'm not aware of any other jurisdiction besides Van Zandt to hold on it. So I'm not sure if it's a matter of transport because he's still in custody with us. So I expect that if what I was told is correct, the sheriff's office would grant him.
I know it was from February 2nd. Yes.
Right now on the website.
Doesn't show holds by the agency, does it?
It doesn't say. Oh, yeah, Judge, I do see, there is a whole domain county on the website.
All right, let's reset Mr. Plunkett then for arraignment on March 8th. So we can get it picked up. Obviously, that may be, we set that at 1:30. Yes, will you check on Mr. Herrera?
Yes.
And if you don't think he's going to show or. Check Mr. Waddell and see if he's talking to the son. If you think it's not going to go, just let us know. We'll cancel the interpreter so you can go about doing other things. Mr. White, you ready? Yes. You want to call any certain one first?
Could we call Mr. Souls up?
Claude Souls, CR 21-246. Mr. Souls, is that Dr. Call today?
Yes, sir. I went back through the discovery on this, Your Honor, and I had made an inquiry into the DA's office previously about a video, and I went back through it again. It's just hard for me to believe that there wouldn't be a body cam. I asked Ms. Heisel to go back and contact the game warden on that because I always kind of had some issues here and there with the wardens. But I think they may have put it onto a flash drive or something and it didn't get downloaded. So Ms. Heisel was checking on that for me because that would be a very significant video. Like I said, I couldn't imagine it. Either it doesn't exist or it got ruined, but it would be hard for me to believe that the warden did make a video or attempt to make a video of that. So she's checking on that for me.
And Judge, I have spoken with the game warden. He told me that that video does exist. He believed that he sent it to our office. We're going to double check our files to make sure that everything we have got copied to Mr. White. If we don't have it, we will contact him to get another copy if that's possible. But he told me that that video should exist in our discovery. So we're going to check on that.
You available on March 8th? Yes. All right, we'll reset Mr. Souls then for call on March 8th at 9 a.m. Mr. Woodall, Edward Earl Woodall, CR 21-255.
Your Honor, Mr. Woodall is hard of hearing.
Mr. Woodall, can you hear me okay? Can you hear me okay? All right. Here, this way. Does he, in the area, want to grab his cane or bring a chair up right here and sit down right there? understand. Does that help you, sir? Does that help you? Can you hear me okay? All right, I'm gonna talk a little bit loud. And if you can't hear me, just raise your hand, okay? Is your name Edward Earl Woodall?
Yes,
And Mr. Woodall, are you a United States citizen?
yes,
Do you read, write, and speak English?
yes.
And have you ever been diagnosed with any type of mental condition? In this case, you are represented by your attorney, Mr. Nolan White. Are you pleased with his representation of you? Are you pleased with Mr. White as your attorney?
Yes,
Do you feel like you've had enough time to talk to him about your case and have all of your legal questions answered?
yes.
Is there anything about this paperwork that you've read and signed with Mr. White that you don't understand? You understand everything? Mr. White, do you believe Mr. Woodall to be competent today?
Your Honor, I believe Mr. Woodall to be competent. I've gone over each, every one of his rights. I believe he's waived those rights knowingly, intelligent, and voluntarily. Would also note to the court, if the court goes along with the plea agreement, that Mr. Woodall will be placed on deferred adjudication. I've informed Mr. Woodall of advantages and disadvantages of entering into such an agreement. Most notably, if he violates any term or condition, the court will hold a hearing to determine whether or not he did in fact violate. The court finds by preponderance of the evidence that he did in fact violate the deferred adjudication. The court can adjudicate him guilty, revoke his community supervision. In this particular case, can sentence him up to 10 years in the penitentiary and $10,000 fine.
Thank you, Mr. White. All right, Mr. Woodall, you have been indicted with a third-degree felony offense of tampering with physical evidence. A third-degree felony in the state of Texas carries a range of punishment with a minimum of 2 years to a maximum of 10 years and a fine up to $10,000. You understand that? And in this case, it looks like your agreement with the state is that you're going to plead guilty to that charge, and they're recommending to the court that I not convict you today, but I place you on community supervision for a period of 2 years, and that you pay a fine of $1,000, court costs of $290, and reimbursement fees of $90. Is that your understanding of the plea agreement? And that's what you want the court to approve today? All right, Mr. Woodall, understanding all of that, how do you plead to tampering with physical evidence? And do you plead guilty to that crime because you are guilty of committing that crime? Has anyone threatened, forced, or pressured you to make you feel like you had to plead guilty today? Has anyone pressured you or forced you to plead guilty? You're doing this because this is the decision you want to do. Okay. And Mr. White, is there any objection to the state's evidence?
No objection.
All right, state's evidence is admitted, and the court does take judicial notice of the defendant's judicial confession. I want to take just a moment and read your case, okay? All right, Mr. Woodall, the court finds that there is enough evidence to convict you today, but the court will follow the plea agreement and approve the agreement. Court hereby places you on deferred community supervision for a period of 2 years, orders you to pay a $1,000 fine, $290 court cost, and $90 reimbursement fees. And the court will take into consideration a cruelty to non-livestock animals in DA 2021135. The last part, the court is going to dismiss and take into consideration another case that the state had against you, and it was a cruelty against non-livestock animals. Okay, so that means that case is going to be dismissed. Okay. All right, Mr. Woodall, I'm gonna have you be fingerprinted. My deputy is gonna fingerprint you right here. And then after that, I want you to go over here and see Mr. Waddell. And he'll give you more information about probation, okay?
Okay.
White, are you ready on your other clients?
Your Honor, I only had Mr. Jay's.
Oh, that's right. Okay, so he's
Had decided to grace
Okay.
us with his presence.
all right. Are you? Sorry.
Speaks enough English to understand that I'm standing for Mr. Manning. So, okay, just that.
That's all we're gonna do. State, are y'all in agreement with resetting the case? Yeah, that's fine. We call Mr. White and then we'll call you up and then we'll call off the interpreter. I may ask you to assist me today on reset. Mr. Espino? This is cause numbers CR 21, 113, 114, and 115 set for docket call. Mr. White, go ahead. On the record, off the record?
Off the record.
On the World Wide Web. Off the record. All right, court will reset Mr. Espino for an additional docket call. We'll set this out. Are you available? We're gonna May 10th or 12th.
10th would be best for me.
All right, court's gonna set Mr. Espino for docket call on May 10th. Mr. Espino, just because I'm resetting your next court date to May 10th doesn't mean that you don't have to report to pretrial release. You gotta do that every month. Okay, so you need to stay in contact with your pretrial release officer and make sure you're doing that. Just because you're not coming back to court till May doesn't mean you don't have to go over there and get drug tested, pay. You still gotta do all those things every month. You understand? Okay. All right, Mr. Herrera. All right, this is cause number CR 21-290, CR 21-316, State versus Jose Guadalupe Rivera Herrera. I want the record to reflect that the case was set at 10 o'clock and the court had arranged for an interpreter, and Mr. Leonard Perales appeared. Mr. Herrera was not present at that time, and so Mr. Perales was excused. Court has received a statement from Mr. Schmidt, officer of the court, who is standing in for Mr. Manning. Mr. Schmidt has indicated that he believes Mr. Herrera speaks sufficient enough English to at least understand the purpose of a passing of today's setting and a reset of the case. And I'm going to conduct the hearing without the assistance of a licensed court interpreter, but I am going to use the assistance of my court reporter, the Honorable Estella Grisham, who is bilingual, to assure that Mr. Herrera understands that we're going to be passing this case today. And Mr. Schmidt, what's the announcement with regards to the case?
Judge, request Mr. Pritchard, Mr. Herrera. So this was all.
Do you think 30 days?
Just request that.
Okay, so we'll reset till March 8th. And we'll try to arrange Mr. Perales on that day. And so at this time, I'm going to ask my court reporter, Ms. Grisham, to speak to Mr. Herrera in his language, Spanish, to make sure he understands that his next court date that he's due back, the pretrial will be on March 8th at 9 a.m. Actually, let's do that at 10 a.m. and I'll try to arrange the interpreter for 10 o'clock, Mr. Schmidt. Sorry about that. Thank you, Ms. Grisham. I'm going to bring Mr. Weiner in at this time. He's only attorney on stand. Good morning, Mr. Weiner.
Good morning, Judge. How are you?
I'm doing great, man. Sorry for the delay. But I thought it might be advantageous to your client. Ms. Jones, yeah, she wasn't here at 9 o'clock and I haven't seen her since. You may have more information on that for me, so I'll let you talk.
The last conversation I had was via email with my client. She told me her car would not start, but that she had a ride and she was on her way. Although I'll submit to the court, if her timeline would have been accurate, she should have been there well by now. So I don't know really what else I can tell you, Judge, or what I could do at this point.
Okay. All right. Well, we'll be in court probably until noon. I'll give her an opportunity to appear before noon. If she doesn't, then I'll have her name called and we'll do a judgment not sign any of the escapees. If there's some issue, then you'll bring that to my attention and we can work on getting them withdrawn or what have you.
I will, Judge. And if she does show up, I'm going to be there at the jail docket at 1:30. So maybe, respectfully, if you held her over, we could handle her case if she does by chance show up.
All right, I'll do that. If she shows up before 12, I'll reorder her to reappear here in the court house at 1:30.
Sounds great. See y'all here in a couple hours.
Thank you, Mr. Weiner.
Bye-bye.
Mr. Evans, do you have any more business? Oh, so he's still got it. Did let's see, so Brandon Harrison? Mr. Lejean? All right, this is cause number CR 21402, State of Texas versus John William Lejean Jr. Mr. Lejean, you are charged by indictment with a third degree felony offense of evading arrest or detention with a vehicle. That type of offense carries a range of punishment of a minimum of 2 years in prison to a maximum of 10 years in prison and a fine of not more than $10,000. You understand that range of punishment? Do you intend to hire an attorney to represent yourself?
Yes, sir. I'm, contact Mr. White, and I'm supposed to have a meeting with him sometime this week. His schedule's busy.
So if I reset you for 30 days, you believe that you would be able to hire Mr. White or some other attorney?
Absolutely.
Okay. All right. So what I'll do is I'll reset you until March 8th at 9 a.m. I'll give you an opportunity to do that. Okay, sir?
Thank you, sir.
We'll have you sign this notice of setting. We'll give you the yellow copy. You'll have the date on it, and then you'll be free to go. Now, Mr. Lejean, I got one more thing I need you to do. I need you to report to the pretrial release department, and you're gonna have conditions of pretrial release connected to your bond. That means you're gonna have to stay drug-free, you're gonna have to drug test, you're gonna have to pay bond supervision, things of that nature, okay? So come on through here and meet with these officers. They'll have you sign some papers real quick, give you a copy, and you'll be free to go, okay? Is Ernest Bowie or Bowie here? So, Vincent Freeney? Freeney is not. Is this your note that his son had rec, waiting on proof of? Mr. Gould? This is a sanctions court hearing, Matthew John Gould, CR 2389. Mr. Gould, I show here that you did your community service and that you've paid off your balance with the counselor.
Yes, sir.
But I do show that you had one failed test on your breathalyzer, meaning that the breathalyzer asked you to submit on February 4th at 10 p.m. You had 2 hours to do that, and it says that you did not provide a breath attempt.
Yes, sir. I fallen asleep. Being honest, I passed out at like 8:30.
Didn't pass out from drinking, did you?
No, sir. I don't drink. I'm allergic to alcohol.
So the probation officer says that they want you to continue in sanctions court till you show a pattern of complying with the test on the breathalyzer as well as your hair follicle testing. Okay.
Yes, sir.
So when was the last time you were in court?
Whenever I reported it, was just Thursday.
I mean, when was the last time you were here in court? Not over there.
Oh,
here.
it was December 16th.
December 16th. Okay. All right, so what I'm gonna do is I'm gonna set you again on April 12th, okay?
Yes, sir.
I want you to continue doing your community service. Have you done all your community service? If you still have,
No, sir. I did 46 hours last month. I think I'm somewhere around 300 left.
okay. So let's continue doing your, you know what you're supposed to do on your community service.
Yes, sir.
And you know what you've got to do on your payments, right? So let's continue to do that. And then no more missed breath tests, okay?
Yes, sir.
All right, we're gonna have you sign this, we'll give you the yellow copy, and we'll see you back on April 12th. You talk to your probation officer. Talk to your probation officer about that.
Yes, sir.
Yes, sir.
Ms. Jones? Ms. Wendy? What's your name, ma'am? Keels. Mr. Stevens. All right, Ms. Keels, this is CR 21330. Ms. Keels, I called your case at 9 o'clock. Why were you not here?
I think I'm pronounced it myself. When I got up, my ride wasn't there, and so I tracked him down, and I called up here to make sure everybody knew that I was coming.
Yeah, your attorney was here at 9 o'clock, and we were gonna take up your case. He had to go back.
And so,
So, all right, so Ms. Keels, I want you to come back at, here 1:30. I want you to come back up here at 1:30, and I want you to continue to wear a mask. You're saying
today,
today.
yeah, I'll stick with my ride on home.
Say that again.
I'll send my ride on home, and I'll stick around here today.
You're just gonna stay around. While you're in the courthouse, I want you to wear a mask. Okay.
Sir,
I said while you're in the courthouse, I want you to continue to wear your mask.
okay, thank you.
All right. And so your attorney will be back at 1:30. All right. So we'll see you back at 1:30. So that's going to be just. Mr. Dodd. All right, this is cause number CR 2383, State of Texas versus Don Gerald Dodd. Mr. Dodd, you are charged by indictment with a third-degree felony offense of tampering or fabricating physical evidence that carries a range of punishment with a minimum 2 years in prison to a maximum 10 years and a fine of not more than $10,000. Court finds that you have requested court-appointed counsel on the basis of you being indigent. Court's reviewed that. The court finds you to be indigent at this time. The court has appointed the Honorable Dustin Wilson to represent you. And the court has provided you his contact information on that form. And I'm going to reset you until March 8th. Okay, so between now and then, you reach out to Mr. Wilson and you begin discussing your case with him. Now, he might not know immediately. He's not going to know immediately. We're going to send him a copy of that and let him know that he's been appointed to represent you, but you may give him a day or two. All right, so he's not going to know anything about your case other than what you tell him, because he'll have to work with the DA's office and get the discovery. So within a couple of days, today is Tuesday, so by Thursday or so, make sure that you've given him a call, introduce yourself, and y'all get going on your case. And we'll see you back on March 8th. And have you sign this form right here, okay? Okay, and then Mr. Dodd, after you sign, meet with Mr. Waddell. Yes.
State for Mr. Rainer. However, I just met with him. He's not yet turned himself in. He's meeting with the bondsman right now to arrange to post bond for that amount. Just wanted to make sure that it wasn't going to be signed until we've confirmed he's in custody.
You know, the DA's office policy that we don't negotiate bond until they're actually in. Given the fact that Mr. Damon, Dahman,
Worry, I've been called worse.
Mr. Dahman obviously flies in and out. I don't want to make him stay here to get this taken care of. We've reached an agreement based on Mr. Raina's situation. That we would agree to a reduction back to 25,000 with the stipulation that he turns himself in. So we would ask that you hold that once he turns himself in, if the court would consider that at the courts.
I told Mr. Dahlman that if he convinced you, that would be convincing to me. So, okay. I'll do
It sounds
So-
like he had some issues on the way coming back, didn't realize that something's legal someplace else, not here. I don't believe it's necessarily an expense.
Once I get notice that he's in custody, then I'll get this. So once he turns himself in, if you want to notify Ms. Tabor again, she'll tell me. Absolutely. And I'll get it signed. We'll get it signed.
Thank you, Judge. All right. Thank you, Judge. My excuse.
Yes.
Thank you.
To you, Patty. There's questions that no.
Just so you see them, you don't have to sign it.
Did Larry tell you he messed up our jury trial last year? Did he tell you he messed up our jury trial?
Oh, yeah, well, no, actually, I blamed it on it. Neighbor.
Might not, it might have been a joint.
Do you have the paperwork last?
Mr. Tabor, he does, yes. Yes. Mr. Dodd. He had a copy of the paperwork. Mr. Dixon, if you'll step up to the podium, please. This is cause number CR 21-211, State versus Tavares Dixon, set for pretrial, Mr. Adams.
Yes, Your Honor. I don't have any pretrial issues to take up today. There is a discrepancy perhaps about, there's some things that need to be cleared up between Mr. Woodwike and I concerning what Mr. Dixon's criminal history is and is not. I've learned something today about how different substances are used socially today that may change what we do with this case. And so I'm asking for a reset for another pretrial setting. Considering Mr. Dixon's residence in Rapides Parish, I'd ask that setting be about 6 to 8 weeks from now.
Is the issue with criminal history, is that really a pretrial issue? I mean, it's not an evidentiary matter, right?
Well, it could be an evidentiary matter if we end up in a trial, but
You're in the guilt phase.
correct. If that came to pass. But I guess my point is, right now, I don't know what, if any, pretrial issues I need to raise.
But I mean, do you expect his criminal history to be the subject of a suppression or a quash?
I don't know. I really don't know. I'm going to look at what the state has. I understand they can't release it to me now. Doesn't make any sense to me, but it is what it is.
Can you release the criminal history?
Or is the standing order, you have to get an order from you to release it to them. That's
No, standing order means that you can't release it based on that order. Yeah. Right? I mean, we make sure.
I was gonna say, my understanding from is that we need a court order to turn over from history. I didn't know, I don't recall that was specifically a provision of the standing order. There are a number of entries that show up on the interstate criminal history for Mr. Dixon that he is telling, my understanding is he's telling Mr. Adams that those are not him, which is possible that does happen. So if we could, we're asking for some time to discuss those issues, whether that's him, that would obviously form a different opinion of the case for Mr. Dixon. If that is in fact not him, those are his entries into his criminal history, somebody else.
Yeah, number 7 on the standing pretrial order says the defendant's criminal history. So this is the court order that you can rely on.
I will turn that over.
This is what absolves you.
I will turn that over to Mr. Adams right now, and then he can review that with Mr. Dixon, do whatever they need to do. We're not opposed to a reset, obviously, whether that's another pretrial or a docket call, we leave it to the court.
If the court wants to set us for a docket call, that's fine.
And I'll always allow you to raise something back up if there's an issue. We can always.
As it stands right now, if we were to try this case, I don't think that I would file any sort of pretrial motion that would be out of the ordinary.
What would that be? What's out of the ordinary?
Well, like, I have the discovery in this case. I do not see the basis for an argument for suppression or anything of that nature. I don't think that there is a question about lab test results or anything like that.
What about this? What if we set April 12th for docket call? That give you the 60 days, over 60 days that you're looking for him.
April 12th,
Are you available that day? It's Tuesday.
that far out probably.
All right, we'll set Mr. Dixon for April 12th. We'll set it at 11 again so that he can make that trip. We'll set it for docket call. I'll allow Mr. Adams to raise any pretrial issues that he has at that day.
Stay with that, Mr. Dixon.
have it, so we're just waiting. Guess we'll just pull him up, do a status. Mom, is it discharge? It's discharge. Great, so actually, so
What were those other settings that you were earlier? Was it 28th? Right.
We won't be talking about that.
Okay. I think that's all I have this afternoon. I've got it this afternoon.
we'll be here with you. We'll do it together.
Are we doing it here?
I don't spoil you like that.
Don't make a great job. Transfer officer.
We converted our transport officers into stay-at-home jail detention officers.
Maybe excited, they're
And you can see it was a not ready section.
You can kill turtles.
You transport, we look like.
That'd be quicker.
I did, yes, sir.
All right, the court has called the following names: Ernest Bowie, Vincent Freeney, Brandon Harrison, Wendy Jones, and Cody Gates. Court has called their names at 9 a.m. They were not present. Court will note for the record it's approximately 11:21. They're not present in the courtroom. Court has had their names called loudly, distinctly 3 times in the courthouse. No response, right, Bill?
No response,
There's been no response. Court will issue judgment nisi and alias capias in each of those cases. Court will stand in recess till 1:30. Same time, same YouTube channel.